Donald Trump can, in fact, win the New York hush money case. The conservative media has been saying that it's impossible for Trump to win because Trump can't get a fair jury in New York. Likewise, the liberal media has been saying that it's impossible for Trump to win because he's so obviously guilty. They're both wrong. There's a very good chance that Trump can win this case. My name is Joseph Hudak. I'm a criminal defense lawyer headquartered in Pennsylvania, but I do cases in every state, typically along with local counsel, and hopefully I can give you expert guidance for understanding the Trump trial. At the end of this video, in each video, I'll give you Trump's scorecard on each issue we discuss. Now, in part one of this video, I explained that the selection of a jury would be very important. And we discussed what type of a jury would be unreceptive to the prosecution's case against Trump. It's not at all like you might think. It's got nothing to do with politics. What it's really about is that if Trump has a smart jury, and it appears that he does, the jury will understand how difficult the prosecution's case actually is to prove. And as I said, the prosecution has to make a two-cushion shot, a 9-ball in the side pocket, and they've got to prove each part of it beyond a reasonable doubt. Trump needs a smart jury to understand what the prosecution's required to prove, and Trump needs a smart jury not to be distracted by all the scandalous material related to the case. So, if you're interested in that, in an outline of what the prosecution is required to prove beyond a reasonable doubt, watch part one. In this video, we're going to discuss the type of jurors who would be receptive to the other side of the case, Donald Trump's side of the case. Now, just for a moment, bear in mind the first line of defense in this case is that the prosecution simply cannot prove that 9-ball in the side pocket two-cushion shot. They can't even prove that beyond a reasonable doubt. But in every case, there are other defenses. I call them the unofficial defenses. For instance, the victim had it coming. Or a variation of that, the victim was so bad the world's better off without him. Or another unofficial defense, it's not fair to prosecute one co-conspirator and not the other co-conspirator who happens to be working with the prosecution. A variation of that might be that it's not fair to prosecute one presidential candidate and not the other. These are not official defenses. They're not recognized by the court, but very often they're the basis of how a jury decides a case. Also, sometimes a little different, there will be an unofficial defense that the jury just doesn't like the way that the prosecution presents or tries to prove its case. This might be a situation where the defendant is in fact guilty, but the police or the prosecution's key witnesses blatantly lied or planted evidence or twisted the facts. Again, these aren't legal defenses. They're not officially recognized by the court, but they very often make a big difference in a case. In the Trump case, again, I've not seen the evidence, but generally it appears that the prosecution's key witnesses will be Stormy Daniels and Michael Cohen, Trump's bookkeeper, Alan Weisberg, who pled guilty to falsifying business records, and Hope Hicks, a very impressive woman who was the White House communications director and seems to now have turned against Trump. And then finally, David Pecker, the owner of the National Enquirer supermarket tabloid that carried out the catch and kill. Now, even if all of these people say and testify what they're expected to say, that might not prove a crime. Remember, as I explained in part one, the key to this case is whether the hush money payment was or was not a campaign expense. that required Trump to disclose it on his campaign finance report. It's unlikely that the judge will allow the jury to hear about this, but the federal government, who you would expect would be the one to prosecute this kind of a case, declined to prosecute. The current Manhattan DA's predecessor, an old school Democrat, also declined to prosecute. But let's assume that Stormy Daniels, Michael Cohen, Alan Weisberg, Hope Hicks, and David Pecker all testify that the hush money was a campaign expense and Trump deliberately didn't report it. Is that a crime? Maybe, maybe not. At the end of this video, I'll give you Trump's scorecard after we analyze all of this. Now again, remember the analogy of a person who wears $500 suits, decides to run for Congress, and buys himself a $3,000 suit to make himself look better in his campaign. That, the campaign finance experts all say, is not a campaign expense. It does not have to be reported. But suppose that Donald Trump did think it was a campaign expense, and Donald Trump did think he had to report it. And then he did not report it, and he covered it up. Is that a crime? It actually is not. You can't commit a crime by doing something that's not illegal, even if you, in fact, think that it is illegal. For example, if you think you're required to report something on your income tax, and for some weird reason you don't want to report it, and you engage in a scheme not to report it, and then you cover it up, you actually have criminal intent to commit the crime of cheating on your taxes. You file what you actually believe is a fraudulent tax return. Then you talk to a tax expert, and the expert tells you that you're wrong. You actually did not have to report it in the first place. So did you commit a crime? The answer is that you did not. You might be morally wrong. You, in fact, wanted to commit a crime, but you actually didn't commit a crime even though you wanted to. So that's what we're dealing with in this case. And Trump needs a jury who will understand this. But let's talk about the unofficial defenses that Trump has in this case and what type of a jury Trump needs to win with these types of defenses. Now again, at the end of this video, I'll give you Trump's scorecard. Now the first key prosecution witness is Stormy Daniels. She is no paragon of virtue. She's been massively rewarded for what she's done. She's a hardcore porn star, and now she's invited on respectable talk shows almost as if she's a celebrity. On some shows, she's treated almost as a hero. For what? She had sex in a hotel room with a famous person. She says the sex was consensual. Morally, assuming that this did happen, she and Trump are both wrong, but why should Trump have to pay her $100,000 not to exploit this? And by the way, it's a secret liaison. If Trump did have sex with her, he probably didn't expect he'd have to pay her $100,000 keep from talking about it in the supermarket tabloids. She was the one. She was the one who tried to sell her story. Is it fair that Trump has to pay her $100,000? He does pay her $100,000, in fact, and then she goes public with it anyway. And now she gets to transform herself from a hardcore porn star in some circles to a respected national hero. There's something very unfair here. For his underlying unofficial defenses, Trump needs a jury who will think that this scenario is simply unfair. One of the jurors, for example, is a nurse. Now, she might or might not be able to perform the sophisticated legal analysis that we talked about earlier, but she probably will have misgivings about the fairness or the unfairness of this scenario. She's a hardworking professional. She works hard for a paycheck. And now she sees Stormy Daniels, who's a hardcore porn star, massively rewarded and granted celebrity status. She might, be repulsed by the unfairness of this. Also, the men on the jury, they might relate to the idea that Stormy Daniels essentially extorted Trump to pay this money. Sometimes a jury will excuse a person for doing something if the person was unfairly put in a position that made him do it. So Trump needs at least one juror who thinks like that. All you need is one. One juror can persuade the others. Next, you've got Michael Cohen. This actually raises the unofficial defense that a jury might get mad at the prosecution for presenting unacceptable evidence. If you watch Michael Cohen on podcasts, he's actually, in some ways, very likable and entertaining. But notwithstanding that, this man has so much negative history, Trump's lawyers will keep him on the stand for days, just going through point after point after point, issue after issue after issue of Michael Cohen's own personal negative history. It reminds me of the John Gotti Jr. trial. Gotti's lawyer, the extremely capable David Lichtman, on cross-examination, he brought out so much negative history about one of the prosecution witnesses that Gotti Jr. actually called him over to the table, told him to stop. It was a massacre, an assassination. Needless to say, John Gotti Jr. was acquitted. Now, likewise, in the Trump case, I would say that the prosecution runs a risk by presenting a witness like Michael Cohen. Trump's lawyers could play hours of podcasts showing Michael Cohen just dripping with pure hatred for Trump. Trump needs jurors who will be mad that the prosecution is even presenting a witness like this. The same applies to the owner of the National Enquirer. Many, if not most people, do not think that this supermarket tabloid newspaper is particularly truthful. It's almost as if he sells 1 million people papers and he tells 1 million people lies or exaggerations or mischaracterizations once a week. So now you've got the prosecution presenting 2 key witnesses that the jury can't trust. Allen Weisselberg, Trump's bookkeeper, has similar problems, but they're a little different. Weisselberg pled guilty to falsifying the Trump Organization's business records. Not Trump's personal records, the Trump Organization's records. But here's where this gets tricky. People very often plead guilty to charges or reduce charges rather than fight their case. Weisselberg did this, but it's not clear if Weisselberg was in fact guilty or guilty of everything, or whether Weisselberg just took the easy way out and accepted a plea bargain. One thing we do know is that Weisselberg is now at the mercy of the prosecution. He must cooperate with the prosecution. Trump's lawyers can exploit that. Trump might be able to make it appear to the jury that the prosecution presented the untrustworthy Michael Cohen and the untrustworthy David Pecker, and now the prosecution's presenting Allen Weisselberg, a witness that the prosecution totally controls. Trump should have been looking for jurors who will think that this is a rigged game, or at least an offensively weak case. Now, I'll give you the final score in a minute, but we also have Hope Hicks, Trump's former communications director. Very impressive, but she's a wild card. She's against Trump, but she doesn't have the endless baggage of Michael Cohen. She doesn't have David Pecker's aura of supermarket tabloids, and she's not beholden to the prosecution like Allen Weisselberg. I expect she will paint Trump in a very negative light, but I don't think she'll appear motivated to mischaracterize or exaggerate or lie the way Cohen or Pecker or Weisselberg might. A final point, these negative undercurrents that I call unofficial defenses, they apply to Trump as well. The prosecution can do to Trump exactly what we've described Trump doing to the prosecution. In my experience, however, these types of undercurrents, or for Trump, unofficial defenses, they seem more to help a defendant than the prosecution. Juries expect the prosecution to be pure and almost perfect. So at this point, with jury selection completed and the trial about to begin, I'd say Trump is up 4-2, possibly 5-2, depending on how some of these issues develop. Please click the like button in the bottom of your screen. In the next video, part 3, we'll explain the beginning phases of trials in general, and especially the beginning phase of the Trump trial.